This video is about jurisdiction. Jurisdiction is power, and in the context of this course, jurisdiction is the power of a court to hear a case. There are several kinds of jurisdiction, so let's go over some of them. A court may have either exclusive jurisdiction or concurrent jurisdiction with other courts. One thing that surprises people is that with some exceptions, you can take a federal law issue to a state court and vice versa. For example, I once represented a consortium of local governments in its suit against a cable TV company under a federal statute, the Cable Communications Act. I took the case to state court because it was closer, it was less expensive, and would have better coverage by the local newspaper. The federal and state courts had concurrent jurisdiction. However, there are some federal laws that require suits brought under them be taken only to federal court. A court may have either original jurisdiction or appellate jurisdiction or a combination of both. Original jurisdiction is the power to conduct trials. Appellate jurisdiction is the power to review decisions of a lower court. A trial court must have both subject matter jurisdiction over the issue of a case and personal jurisdiction over the parties of a case. Subject matter jurisdiction is pretty easy. Courts have the power to hear certain types of cases. A court that does not have the power to hear a divorce case, for example, cannot hear divorce cases. A court that does have that power can. So don't try to take a bankruptcy case to the divorce court. Personal jurisdiction is much more complicated and not as relevant to your needs for learning legal research, so I won't be covering it in this class. It would be better covered in detail in a procedure class, which perhaps we'll teach later. Basically, it means that a court has to have the power to order you to appear before it, and if it doesn't, then the case has to be brought in another court. Now let's look at the subject matter jurisdiction of the California state courts. I was going to cover all three levels and then decided that the Court of Appeal and the Supreme Court weren't really necessary at this point. The Superior Court has original jurisdiction over California's civil and criminal cases. It also has appellate jurisdiction over some things. For example, it hears appeals from its small claims division. Now let's talk about the subject matter jurisdiction of the federal trial courts. The U.S. District Court has subject matter jurisdiction over a case only if there is a federal question involved or there is diversity of citizenship and the required minimum amount of damages is alleged. Now I know what you're thinking. Huh? So let's break it down. A federal court has to have either a federal question or diversity of citizenship. Federal question means that at least one of the issues is about either the federal constitution, a federal statute or regulation, or another federal law like an executive order. Diversity of citizenship means that the plaintiff and the defendant are not from the same state. If there are multiple parties, none of the plaintiffs can be from the same state as any of the defendants. And there must be at least $75,000 in damages alleged. This is called the jurisdictional amount and is raised from time to time. Back in the early 1800s, when this was created, there was probably a good reason for the grant of diversity jurisdiction to the federal courts. What were the odds that a Yankee from Massachusetts could get a fair trial from the good old boys in an Alabama state court? Back in the 1970s, when I was in law school, the jurisdictional amount was $20,000, and we were assured that diversity jurisdiction would be eliminated soon. It is diversity cases that clog up the federal court. Now, nearly 50 years later, we still have it. The next video will be about the doctrine of stare decisis.